Welcome to Compass and Clock. I'm your host, Karen Copeland. This infotainment podcast explores how to live your best life now and well into retirement. We'll discuss topics in financial planning, housing, and insurance. We'll talk wellness, relationships, and leisure activities. A full, active life requires planning for your goals and preparing for the unexpected. I'll introduce you to a variety of guests, from knowledgeable experts to folks sharing stories of their life experiences and so much more, because life is big. All is intended to help guide you in planning for what you need now and at any age. Like and subscribe so you don't miss a thing. Today, my guest is Tony Hinson. Tony is an attorney in Poulsbo, Washington, with over 24 years of legal experience. He focuses on estate planning, elder law, estate and gift taxation, guardianships, and probate matters. Tony is also a 2016 recipient of the Apex Award. This honor is awarded to a Washington State Bar Association member who exemplifies the spirit of professionalism in the practice of law, as defined in the Washington State Bar Association's Creed of Professionalism. Congratulations, Tony, and welcome to the program.
Thanks, Mary. It's a delight to be here today. I'm looking forward to speaking with your audience and discussing estate planning, one of my favorite topics.
Yes, it is. And as you just alluded to, our topic today is we're going to talk about legal documents 101, what they are and how they make up your estate plan. So I'm just going to jump right in with my first question, which is, what is the definition of an estate plan?
You know, an estate plan, it's a broad-ranging approach to making sure that decisions that need to be made either for you or after you pass are able to be made. So really, it's got a couple of different components. One is the part before you die. People think, what's going to happen after I die? That's my estate plan. That's true to an extent, but you need the documents that are in place before you pass if someone needs to step in and take charge of your affairs and manage your affairs for your benefit. And then, of course, once you pass on, your estate plan is really your opportunity to leave your imprint, to leave your footprints behind to your heirs, to your spouse, to charitable organizations that are important to you, really leave behind a legacy of what was important to you and how you'd like to be remembered.
And I just want to clarify here, with an estate plan, it doesn't matter how much or how little you have or whether you own a home or not, because I don't want that word estate to throw people off.
Absolutely not. Really, an estate plan, you know, it's designed for people who need to be thinking about it. If someone depends on you, so you're a young couple, typically not thinking about estate planning, but you've got kids and somebody would need to take care of those kids if something happened to both parents. Something would need to be done with money that would pass to those children. They couldn't receive it outright. If your kids are 10 years old, somebody's going to have to step in and both take care of your children and manage the money that you would leave them until they're able to take care of themselves and manage their own money. So a lot of people who don't really think about estate plans really should be thinking about estate plans.
Gotcha. So why don't we talk about what the basic documents are that make up an estate plan?
Great. Well, 3 for certain, a 4th is there for people who would like to have it. The first document is really either going to be a revocable trust or a will. And that's kind of the bedrock of what happens with your estate once you pass on. Where does your estate go? If you've got family members you want to care for, if you've got family members who need special types of trust established for them, you've got charities are important to you, or the organizations are important to you. Really, what happens to your property after you pass? What kind of a legacy do you leave? So that's your will, that's your revocable trust. And I've got a feeling we'll be discussing the differences here in a few minutes. The other 2 documents that are vitally important are those documents that provide for your care during your life. And those are a durable power of attorney for healthcare and a durable power of attorney for financial decisions. And they fill very different roles. One assigns someone known as an attorney in fact, often called a power of attorney, but the person is really your attorney in fact, who manages your financial affairs for you, who takes care of your finances, who takes care of making sure your accounts stay current, your taxes are filed, all that really exciting stuff. make sure that it gets done. The power of attorney for healthcare assigns someone to make informed consent decisions on your behalf for your basic healthcare needs all the way up to major surgeries.
And
The fourth document, it's what is commonly known as a living will. That's a document that states if you end up in either a permanent unconscious condition or a terminal condition, and you're not capable of making your own healthcare decisions, you're being kept alive by some means of artificial support, either ventilation or dialysis or PEG tube or some other, or a combination thereof of methods to keep you going. And physicians have determined that basically this is as good as it gets. You're either going to be in this permanent unconscious condition or in this bedridden terminal condition. You're not going to return to anything approaching a normal quality of life. The living will, advanced medical directive, directive to physicians, declaration, it goes by a lot of different names, simply states your desire that artificial means of support be removed and you be allowed to die a natural death. And your healthcare attorney, in fact, is the person that would tell the doctors and the medical professionals to make that happen. So that fourth document really is a reflection of your faith views, your ethical views, and is not necessarily for everyone. Most clients do want it. So really the four basic documents: a will or living trust, a power of attorney for healthcare purposes, power of attorney for financial purposes, and a living will.
great. So in the state of Washington, does someone want a will or a revocable living trust?
Well, in the state of Washington, we do the majority of our estate plans using good old-fashioned wills. If you listen to financial planning shows, read financial planning newsletters, these folks will almost always push you towards a revocable trust. And in many states, California, for example, Florida is another good example, the probate system is such that you want a revocable trust. And we'll talk about the differences here in a moment. In Washington, due to the simplicity of our probate system, we do the vast majority of our planning using wills. So we can, from an estate tax planning point of view and from a legacy planning point of view, we can use either document. A will or a trust work pretty much the same way. When we're doing Medicaid planning for couples, however, we have to use wills. So we're fortunate in Washington that our probate system kind of gears us toward wills anyway, because they are actually the only choice when it comes to Medicaid planning.
Okay. So will, that's a common word that you hear. What does a will actually do?
A last will and testament basically tells the world what you want to have done with your property, who would take care of your children, and how people and organizations that receive property that you have, how they receive it. Do they get it outright in trust in the terms? It's a document that's executed, has to be signed by the testator or testatrix. In Washington, we still use gender-specific pronouns for that. It has to be witnessed by two people. And then in most cases, there's an affidavit prepared for the witnesses that allows the will later to be admitted to court without any supporting witnesses allowed. So it's a testament of your desires after your passing. It's executed with a lot of formalities to make sure that it is bona fide and reflects your desires, because let's face it, you're not around to really tell the court what you wanted anymore. So that last will and testament is your last statement of what's going to happen.
Okay. And you mentioned also revocable living trust. So what does a revocable living trust do, and how are the two different, the revocable living trust to the will?
Great question. So the will is going to work its way through the probate system of your state. So it's going to be overseen by a court. The processes are called for by state law to specifically tell the personal representative or executor how they are to administer the estate and how they are to ultimately pay off your creditors, distribute your assets, and close up the affairs of your state. So it's very much a court-driven procedure. In Washington, however, we draft wills which are called non-intervention wills, which essentially let the personal representative or executor administer the estate without direct court oversight. So it's a very streamlined approach to estate administration, but it is ultimately under the auspices of a state court. The revocable living trust approach does a lot of the same things, but there's no need for court involvement unless there's a question or a controversy or something arises like that during estate administration. So a trust is a way to pass property either outright or in a subtrust. Trusts can have several subtrusts, as a matter of fact. Pass property to your beneficiaries without involving necessarily a state court and without involving court oversight. So in states where the probate system is very court heavy and very expensive, revocable trusts allow for the administration and the state kind of outside the purview of the court. Again, unless there's a controversy or someone has an issue with the estate administration, courts are always there for that, but it doesn't require the court to oversee the administration of the estate. So again, very helpful in states where the probate system is a bit more complex and a bit more expensive than here in Washington, and especially helpful for Washington residents who may own real property in other states. Oftentimes, if we have real property in state Washington, maybe another parcel in California, maybe one in Arizona, without a revocable trust, we would have to open up a probate here in Washington, which isn't that big of a deal, but then we'd have to open up another probate in California and another probate in Arizona. We'd have 3 probates going at the same time. If we have a revocable trust, all of that property transfer can be effected without having to go through the probate system in those other states.
Well, that definitely has its benefits, I would say then. Okay, so my next question would be, you said you would use a will most of the time in Washington. When would a trust be more appropriate? It sounds like you kind of just answered that, if I'm not mistaken, so I just want to clarify.
Yeah, more or less. The key example is a client who has real property in several states, and particularly some states have got streamlined approaches for that, but many don't. And as we all know, a lot of people move to Washington from California. California has a very, very court-heavy probate system. People generally do not want to go through probate in California for that reason. But frankly, if you've got real property in more than one state, a trust makes a lot of sense. It speeds up the estate administration. It allows for those real property parcels to be transferred out to ultimate beneficiaries without having to go through a court process in each state. The other example is if you have highly confidential portions of your estate plan. Wills do become public documents. Generally, people don't, download them for reading pleasure, but they're there. So people can pull your will down if it's admitted to probate. And if you've got terms in there that are very sensitive, perhaps there's a non-pro rata distribution to your kids. One child is disinherited, the other kids get it all. Or if you've got beneficiaries with special needs that you don't necessarily want to be part of a public record, a trust is a very private document, is not admitted to probate, does not become a public record. Now, even with a trust, it's important to know you'll still have a will. You'll have what we call a pour-over will, which is a very simple will that basically says, hey, look, anything I didn't put in my revocable trust during my lifetime, I leave to my revocable trust. And that's largely it. So that will is admitted to probate if necessary. The items are moved over into the trust. And then so the public record in that case simply refers to the trust but does not have the specific terms.
So the way you've just mapped out and explained all of this to us, for the listeners of the Compass and Clock Infotainment podcast that are outside of Washington, can you go into just a little more depth of how it would apply to their state, what they should be, who they should be talking to, where they should be looking, et cetera, how they should make this decision?
Absolutely. It's important to note I'm a Washington attorney, so I cannot provide any kind of advice for residents of other states with respect to those state laws with estate planning. The basic structure is the same in each state. Notable exception is Louisiana, who has a very, very different legal system than the other 49 states. And for residents of Puerto Rico, a very, very different legal system than the majority of United States states. So it just illustrates the fact that if you are a resident of state A, we'll just put a letter in there, you really do need an estate planning attorney who's licensed in that state and experienced in that state law to put your estate plan together. Now, if you execute a will in any state and move, that will is still valid. If it's valid where it's executed, then another state will recognize it. The issue is, though, state laws are different. And in really very few areas are they more different than in the probate and trust areas. States can have their own quirks. As I just mentioned, Washington's got a simple probate system. California does not. So it's important that your particular estate plan be put together specifically for the state in which you reside and by a professional that works in that state, licensed in that state, and is familiar with that state's probate laws, that state's laws of intestate succession if necessary, who gets your property if you don't have a will, that can come up from time to time, and who is familiar with the real property laws of that state, and if the state has an estate tax of its own, apart from the federal estate tax, is familiar with that state's estate tax as well. So it's a highly state-specific area of the law. You definitely need a professional in the state that you live in.
So to recap real quickly, if you have all your estate paperwork put together in the state of outside of Washington, and you choose to retire in Washington and you're going to reside here, you should consider seeing an elder law estate planning attorney to make sure that your documents are updated to the appropriate state.
Absolutely. You definitely want those documents to be redrafted under that state's laws. If you have a trust, then we would either restate the trust, which means basically we keep the trust in place, we just change the terms to match Washington law, all the way up to drafting a whole new trust. Not to panic, listeners. If you move to a new state and you've got estate planning documents which are, drafted in the fourth state back that you lived in, again, if your documents are valid in the state that you sign them, they're going to be valid in the state that you move to. It just could more than likely present some complications if you were to pass on and we had to probate your will that was drafted in, let's say, Iowa in Washington. It adds some complications there. So always a good idea after you move to a new state to sit down with an estate planner and get your documents updated.
Good advice. So we were talking about wills, trusts. Why don't we jump into POAs, power of attorneys? What kind of POAs are there? We talked initially about healthcare and financial.
Absolutely. So there are two broad categories. There's a general power of attorney, and then there are specific powers of attorney or special powers of attorney. Now, if you've ever sold a piece of property or entered into a financial transaction, or for service members who deployed, you may have signed what are called special powers of attorney that are very, very limited. Maybe a power of attorney for childcare, a power of attorney to sell a specific parcel of land. So those kinds of powers of attorney are limited in scope, normally limited in time. They expire after 6 months or after a year. And if you were to lose competency, so you signed this power of attorney, and then for some reason you are no longer competent, the law will extinguish those special powers of attorney unless they are durable powers of attorney. So the other broad category of powers of attorney are general powers of attorney. These are very broad reaching. Basically, you assign an attorney, in fact, to do anything that you could do in your stead. So not necessarily do you even need to have lost competency. You can assign a general power of attorney to a spouse, to a child, to really anyone to act on your behalf. And general powers of attorney are very broad.
So then what does the word durable mean then when you pair it with a POA?
Great question. So again, the law assumes that if you sign a legal document like this and then lose competency, well, the law is going to step in and go, well, wait a second. We're going to invalidate all these powers of attorney because we don't know what this person intended to have happen if they weren't around to monitor things. A durable power of attorney, however, tells the world, hey, look, I'm going to sign this power of attorney, and even if I were to become incompetent, I still want this power to be with this person to manage my affairs. That tells the courts, tells the world that this is the person you trust, and even if you're not around to monitor them, you're no longer competent really to manage your affairs, they still are the person that are going to act for you. The vast majority of the powers of attorney that we draft in our office are durable because people are putting plans in place for just that potentiality. So you want people assigned and want people appointed who would have the authority to act if you couldn't.
Okay. So what are things you should think about for a durable power of attorney for asset management, which would be the durable power of attorney for financial side?
Gotcha. We talk about a lot of different topics when I meet with clients on this. I'd say the most popular client or topics and the ones people really put a lot of thought behind. One is digital assets, your Facebook account, your Twitter account. Not such an issue 15, 20 years ago. It has become a huge issue. Who can step in and manage those accounts for you? Who can tweet for you? Who can tell the world on your Facebook page that you've moved on to a different stage of your life? The power of attorney should clearly specify and give your attorney, in fact, those kind of powers. IRAs. For years, we put what's called a general banking power into a power of attorney, and most IRA custodians would allow that clause to let your attorney, in fact, move your IRA around, adjust beneficiary designations, if necessary and appropriate for your estate plan. A few years back, they got a little bit more specific. They wanted powers clearly enumerated in the power of attorney as to what your attorney, in fact, can do with IRAs. So we talk about that and try to lay that out in detail so that the IRA custodians know exactly what that scope is. Another great area is Medicaid planning. We want to have the ability that if there needs to be an asset shift between spouses or even gifts to non-spouses in order to qualify a person for Medicaid assistance, that power needs to be in the power of attorney as well. And then finally, just straight gifting. Do we want the authority of your attorney, in fact, to make gifts on your behalf, to give large presents to your children or to your grandchildren? We might do it for estate tax purposes. If your estate is going to be potentially over the estate tax limit, that gifting authority will allow us to spend you down a bit. Always remember, though, that your attorney, in fact, has to act in your best interests. So they can't, gift you into poverty. That's not being a good fiduciary, and a court would stop that. But if it's appropriate and possible, having a gifting authority in there is a great thing to have.
Okay, so with the power of attorney and these documents are drawn up, do you want it to be delayed or immediately effective upon signing?
Great question. This really comes down to the client's desires. We talk about this quite a bit in my client meetings. The choices really are, do you want this power of attorney to lay dormant until such time as you would become incapacitated, and then your attorney, in fact, would seek a letter from your primary care physician in most cases that you're no longer competent to manage your affairs. That's known as a springing power of attorney. Healthcare powers of attorney are always springing because you're making your own healthcare decisions until you can't. But the financial power of attorney, if you desire that fail-safe in there, if you want that pause in there, you don't want the person to immediately have the power to act on your behalf, the springing makes a lot of sense. Frankly, for most of my clients, we go with an immediately effective power of attorney for really two reasons. One, if the person needs to step in quickly, we've had a cataclysmic health event and they need to come in very fast and act. We don't have that need for a letter. We don't have a need for any of that. The person can just start acting for you immediately. And if it's someone you put in place that you trust implicitly, that's not a problem. The other circumstance these are helpful for is if the person gets on, is a little bit older and just doesn't want to manage the mundane parts of their financial world anymore, they can tell their power of attorney, hey, you're on board. My own father did this with me. I was voluntold, and I started taking over his affairs, and his power of attorney was immediately effective, and it works really well that way. So for a couple of different reasons, I tend to favor immediately effective, but it is very much a client decision.
Okay. We only have a few more minutes here and I have a few more questions. So let's talk about the healthcare durable power of attorney.
Those are, so two aspects to those. One, the healthcare attorney, in fact, is the person who will make informed consent decisions for you when you can't. So again, these are always a springing power of attorney, because if the doctor can ask you, that's who they're going to ask. But this assigns someone to make those kind of decisions. If you need surgery, if you need routine care, really any kind of healthcare decision that requires somebody to sign a waiver, your attorney, in fact, can do that for you. And if there's an elective procedure that needs to be done, and you would make that call naturally, your healthcare attorney, in fact, can do that for you as well. They become your HIPAA agent. They can receive your health information in order to make these kinds of decisions. And all the way up to, remember I was mentioning the living will. If you've signed a living will, a declaration to physicians, that states your desires, someone is going to have to direct the medical professionals to remove those artificial means of support. And that is very much the attorney in fact for healthcare. So important to have discussions with this person you've appointed so that they know specifically, and hopefully in your own voice, what your desires would be in those circumstances.
And if I understand correctly, the person that you assigned and had the conversation with to ask if they would accept this durable POA authority, it could be the same person for both financial or healthcare, but it doesn't have to be, correct?
Absolutely. So two things there. One, please have the conversations with the people that you've appointed. A crisis like this is really a bad time to find out that, hey, by the way, you're the attorney in fact, so you're on board. So it's great to have those conversations ahead of time. Definitely can be the same person, but if you've got someone who is very knowledgeable in the medical area, or just is that kind of a personality that would be able to make those kind of decisions well, maybe they're not such a great financial person, and you've got another person in your life who's great with numbers, but really might not be comfortable making healthcare decisions. Absolutely. Your two attorneys, in fact, would be different people. Often the same, but just about as often, we do have different people you appoint because people have different personalities, different skill sets, and you assign them different roles.
I have one last question. You talked about a living will earlier. Is that the same as a DNR?
Excellent question. No, it is not. So a living will, think about as a very deliberate planning document. So typically, we're not at a crisis mode of healthcare. There's maybe something has occurred, an automobile accident, a stroke, a heart attack, some other event which has led to a steady state. You've entered into a point where life support mechanisms have been put in place. Physicians have been hopeful that things would improve, but they just haven't. And we've hit a decision point as to whether or not these mechanisms are kept in place. So a very deliberate planning document in most cases. The DNR, also known as a POLS in Washington, the Physician's Order for Life-Sustaining Treatment, it's a very bright neon green form. You cannot miss it if you see it. That states that if you end up in a situation where you're coding, you have a cardiac arrest, you're not breathing, your heart isn't beating, it's very much a crisis decision point, that POLS or DNR tells healthcare professionals if you want to be resuscitated or not. So in most cases, healthy individuals really don't need to have necessarily a POLS in place. You need to definitely discuss that with your physician. It's a medical document. It's signed by a doctor. It is not a legal document. We don't do those here in the office. But the living will is very much a legal document signed in our offices, and it tells healthcare professionals what the decision points would be after treatment has been tried and unfortunately is just not going to be successful in bringing you to a normal state of life. The DNR POLST, crisis planning, you're coding out, what do we do?
Wow. So that was a lot of planning that we discussed, but all great information. So I want to say thank you, Tony, for educating us on the basic legal documents that everyone should put in place to protect themselves and their loved ones. You definitely are a wealth of knowledge, and thank you so much for joining me today, but we must say goodbye for now. Until
Thanks.
next week, folks.
Great to be here. Thanks a bunch.
Thanks, Tony.